2 minutes? Alright, so my case was Griggs versus Duke Power Co. Duke Power Co. is a power company that was known for discrimination, and they only had 14 black employees, and all those black employees were in the labor department of the company. Well, in 1974, the Civil Rights Act of 1964 passed a title that made it so the company was able to put restrictions on whether or not you could be employed based on tests, but it did not describe these tests. So Griggs and a bunch of other black employees went on strike, and because the Duke Power Company made them so they had to have a high school diploma and get the similar grade on an aptitude test as high school graduates in order to get outside of the labor department. And so they were suing the company, and the district court went in favor of the company, saying that since the title didn't describe it, didn't matter. And so the Supreme Court overturned it and said that the Supreme Court overturned it and said that since the test didn't have anything to do with the job at hand, what they had to be doing to work, that they had no relevance to, since they had no relevance to the job, they did not apply to the Civil Rights Act, so that they were unlawful.
Concerning the applications to a university of 3 students. Those students were Barbara, Grutter, Jennifer, Gratz, and Patrick. So they were denied admission. That is that uncommon, but it was the grounds on which they were denied. Brings right to the question. Why? It was because of race. Now, the university openly admitted that it uses race as a factor in its admissions rate. And the students brought this up in court. So the district court, under I think James Powell, he argued that it was not a kind of compelling state interest, which was what they stated it as. And from there went to the Supreme Court, which in Grutter's case, it was decided that the legality of using race as an admission factor. In a 6-3 decision, the program was in fact legal. It just has to be nearly tailored, which they found it wasn't. 1995 to 1998 brings us to our next case, Gratz, and which the application of the system is question. Now, they gave 20 points to any underrepresented applicant. So that's about 1/5 of the total points needed to be guaranteed admissions. This has given them an unfair advantage over the rest of the applicants. So it was a 5-4 decision in favor of Gratz. That was unconstitutional legal reasons.
Okay, so from what I could hear, he said that something about division, but first first off, there's still schools today that are all black, or not all black schools, but mainly black schools or mainly white schools, and there's scholarships for certain races so that they can get more money to be admitted to schools. My case is more important because you go to school to get a job. When you enter the workforce, depending on the company, like Duke Power Co., if there's loss, or if there's tests that you have to take that you're not able to take, or you're not able to score high enough on because they're being racist against you, then you won't be able to work, regardless whether you have education or not. If they put certain...
Yes, like in regards to that, in order to get a job, oftentimes you have to actually have an education. Now, the problem with the Grutter and Gratz case is that they were offering this to underrepresented minorities to get into this university. The problem, the difficulty arose from how they applied this. They essentially were giving, if you applied, you got it. So it wasn't narrowly tailored. But that's the point. You have to actually get an education and actually have a job nowadays. So it's an important factor in our lives. If you don't have any